Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE accredited webinar titled Immigration Reform and the Workplace, an overview of legal and legislative developments. Before I introduce our speakers, I have a few announcements about today's event. For our phone participants only, if a problem arises during the program, dial *0 for the operator. And for continuing education purposes, those parties listening by phone only, please be sure that you have identified yourself with the operator. If your name has not been taken, please dial *0 now and an operator will take your information. Those audience members listening via computer do not need to identify themselves with an operator. In order to process your CLE credit, please download and complete the Immigration Reform and the Workplace form that you will find via the gray CLE widget in the bottom dock of your webcast console. Please promptly return those forms as instructed within them to the LexisNexis CLE team. We suggest downloading these materials shortly after the program begins. All New York attorneys will receive more specific forms following this event. Please consult your local rules for further guidance on CLE or contact LexisNexis at cle@lexisnexis.com. All attorneys joining us today will be given 2 4-digit codes randomly announced throughout today's call. Please be ready at all times to write these codes down so you may enter them on the appropriate CLE paperwork. These codes are required to receive your credits and verify your active participation in today's call. You must attend the entire event in order to receive these codes. Again, all CLE material may be downloaded via the gray CLE widget in the bottom dock of your webcast console. The panelists welcome your questions. You may submit your questions via the Q&A tab of the webinar platform throughout our program today. The panelists will attempt to address as many audience questions that are submitted through the Q&A tab as possible during the last few minutes of the program. Please keep in mind all questions may not be answered due to time constraints. We will not be taking questions over the phone lines and will only receive questions through the web portion of the program via the Q&A window. And now I'd like to introduce today's speakers. Complete biographies are included with the PowerPoint materials. Alan Kay is a nationally recognized expert in the field of United States immigration and naturalization law. He works with individuals and both large and small employers to assist with visas, I-9 audits, and other immigration and naturalization issues. Mr. Kay is a nationally recognized expert in the field of United States immigration and naturalization law. Professor and attorney Raul Manchanda has worked for one of the largest law firms in Manhattan, where he focused on asbestos litigation. At the United Nations Commission on International Trade Law in Vienna, Austria, Mr. Manchanda was exposed to international trade law, arbitration, alternate dispute resolution, and comparisons of the American common law with European civil law. In addition, Mr. Manchanda has been advised on, consulted on, prepared, and filed tens of thousands of non-immigrant and immigrant visa petitions. As Managing Director of Paragon Geo-Immigration, Elaine Martin manages Paragon's global immigration practice, covering over 150 countries. She has practiced immigration law exclusively since 1997 and established her own immigration law practice in 2008. Ms. Martin speaks on global immigration and on compliance issues in the context of international assignments at conferences around the world. Before we begin today, I'd like to announce our first CLE code. Attendees, please note, the first CLE code for today's webinar is 4519. Again, the first CLE code for today's webinar is 4519. Panelists, the floor is yours.
Okay, this is Alan Kay. I'm going to start off by giving our listeners an I-9 update and suggestions in the time that I have. We have a new I-9 form, which should be on the screen. We're getting to it. It's a 9-page form. The first few pages are instructions. The essential form is pages 7 and 8. Page 7 is to be filled out by the employee. Page 8 is to be filled out by the employer. And page 9 is a list of acceptable documents. Now, when a new hire is coming on board, you're supposed to give him or her the entire 9 pages, meaning you give the person who's coming on board the instructions, the form, and the list of acceptable documents. And you should see on the screen the first part, which is the employee form to be filled out, and that would be followed by the second part, which is the form for the employer to fill out. Somewhere along the line, I think we may have misplaced the last list, which is a list of acceptable documents, but I'll tell you how to get to that. Now, some very useful information about I-9s and how to get the I-9s. And one of the things you can do is go to something called I-9 Central, which is www.uscis.gov and an oblique line -I-9 Central. And you'll get I-9s from them. You'll get a lot of useful information. Or you can call 1-888-464-4218. Now, there's also a very useful handbook for employers. It's called the Form M274. That has also been revised, and we have a picture of the handbook for employers, which I hope I can bring up. But in the meantime, the handbook for employers you can obtain by www.uscis.gov/forms. And it's about 60 pages, and it's very up to date. So the main thing you need is these 9 pages with the 6 pages of instructions, the 2 pages of the form, and a list of documents. Okay. Now, if you have questions about how to answer these forms, any questions, you can call 888-464-4218. That's a government line. Or for questions about the forms, uscis.dhs, like Department of Homeland Security, .gov. Now, it is suggested, but not required, that employers print the form front to back, so everything is together. So what an employer should do, don't have to, but it's recommended, is to print page 7 and 8, 7 being the form that the employee fills out, and 8 being the form that the employer fills out. Print them back to back. Okay. So again, now as far as the documents are concerned, you should be able to get the list of documents by going to one of these websites that I gave you. We were trying to get it printed up. I'm not sure we made it. Now, so you send the employee a copy of the form they need to complete before they're starting work, and you send all 9 pages to the employee. Now, you can complete the I-9 as long as you have offered the employee a job and the employee has accepted the job with a future date of employment. They can start filling out the I-9. If the employee is a permanent resident, you can't ask for that. You have to ask for certain things according to the list of acceptable documents. You can ask for something from List A, which are documents that establish both identity and employment authorization, or you can ask the employee for something from B and C. And they'll have all this in this package of 9 pages that you've sent them. And you can't specify what they're going to show you. They are free to pick either something from List A, which establishes the 2 key components, identity and employment authorization, or something from B and C. Okay. Now, there's another part of the employer form which has to do with re-verification, and that's Section 3, and that's for rehires or people who've taken a leave of absence or something. You would use the re-verification in Section 3. There's a Spanish version of this form, but it can only be used in Puerto Rico. So if you're in the United States, use the English version. Now, again, you can write in the anticipated start date when you're filling out the form, because the employee hasn't started yet, but the anticipated start date changes. You have to fix it so it matches the payroll records. The employer has to complete Section 2, that's the employer's form, within 3 days of hire. Now, as far as the I-9 is concerned, you have to keep and maintain the original I-9, not a faxed copy. The Department of Homeland Security is available to give you a customized webinar, and for that you go to eVerify at dhs.gov, try to arrange a customized webinar. Okay. Now, when you hire the employee, the employer will show you something from A or something from B and C. Now, you don't have to make copies of what they show you. I think it's a good idea. Some other lawyers disagree with that. But if you do make copies of the documents, you have to do it for everybody. And you then keep the things you made copies of, the things they showed you, with the forms. Okay. Now, all employees, again, as I said, have to have access to the instructions and the list of acceptable documents when they're completing their form. You can do Section 1, the employee's form, and Section 2 at the same time, and again put in the anticipated start date in Section 2. Now, employers can have anyone act as their representative on their behalf, but the employer is still responsible for any errors that are made on the form. A notary doesn't have to put in the seal, but the notary is acting as the employer's representative in filling out the form. Now, the employee, again, fills out Section 1, the employer fills out Section 2, and again, someone filling out on the Section 1, someone can sign as a preparer, and they accept responsibility for what's put in as the preparer. Now, the person completing Section 2 must be the person who reviews the actual documents and the IDs and signs. Now, if the person shows you an employment authorization document, which is one of the List C documents, and it expires, the employer keeps a record of the employment authorization document expiring, and under Section 3, the re-verification has to re-verify when the employment authorization document expires and gets it re-verified. Okay, so for re-verification, most of the time you use the new I-9 form, not the old one. Now, on the form, if you look at the employer's form, Section 2, this is a new form, and they want the employee's last name, first name, and middle initial on the top of the form. So make sure that you do that. You put in you put that in Section 2. Okay. Now there is a very good book which gives you a lot of instructions on how to fill out and maintain the I-9 form. And this is a book that's just published by a friend of mine whose name is Ann Allott, A-L-L-O-T-T. And you can go to www. You can Google her, Ann Allott, or you can go to LexisNexis.com, and they will. I think they're selling the Ann Allott book, and I think she tells me that within a few weeks it will be updated to include the new I-9 form. Okay. Now, there's some very useful information in the on the immigration website, and they talk about common mistakes that people make and how to avoid them. It's something that you should look at, and you'll see that on the USCIS website. Now, let me just go through a few important items. These are a series of questions and answers from USCIS. Are employers permitted to send employees just pages 7 and 9? Or do we have to send all the pages to the employee prior to employment to complete? And I've told you that the employer must provide or otherwise make available to the employee the pages that contain the instructions and list of acceptable documents. This means pages 1 to 6, which is the instructions, and 9, which is the list of acceptable documents. The form carries with it an email address and a telephone number. So the question is the new email address and telephone number fields optional? The answer is yes. These fields are voluntary. The employee may enter NA in these fields if they choose not to provide their email address and telephone number. Next question. Now that the form I-9 is no longer a single page, can double-sided copies be used to decrease the number of pages? Yes, we encourage this as a best practice. That's the Immigration Service saying that. Now, for verification purposes, can we ask to see a Social Security card? No. Employers cannot ask to see specific documents. Employees must be allowed to choose which documents they want to present from the list of acceptable documents. Now, I noticed in Section 2 of the Form I-9, I've got 30 seconds. So there are two additional documents, two additional boxes that have been added, and those were added just to make it a little easier to accommodate the employers in filling out List A. Last question I think I have time for. Can we accept fax copies of Form I-9, or do we need the original? Answer. Form I-9 retained in paper format must contain original handwritten signatures. So I think I'm just about out of time, and people can get back to me by email or any other way, and I'd be happy to give you additional information, but I'm out of time. So thank you for listening, and I'll turn to Elaine.
Thank you. I am moving forward now to my slide. There we go. Thanks, Alan. I am going to talk about the importance of the compliance with these requirements, both of the I-9 form and the regulations, but also a little bit on I-9 or on immigration and other compliance issues generally. That could be the topic of an entire 90-minute webinar itself, so I am only going to be able to touch on some of these very, very superficially, unfortunately, but I have given many presentations that go into these in more detail. And I'm sorry, there's a lot of paper rustling in the background, so it's difficult for me to focus. So I have given webinars that will discuss these compliance issues in more detail, and you could find them on our website, and I would be happy to give you more details and send you links. But at the moment, I'm going to talk about the I-9 compliance and why it matters. And some of the bullet points on this slide are going to explain why it matters and why you should care that your companies are complying with their I-9 obligations. The Obama administration, along with previous administrations, but the Obama administration in particular, has stepped up enforcement of immigration regulations, and it's not just in the United States. I manage global immigration now, and it's a common theme in other countries as well that enforcement of employment-based immigration laws is really being stepped up because it's seen as a way of raising revenue without raising taxes, and usually finds favor with many voters. So many countries, not just the U.S., are increasing their investigation of foreign national workers and making sure that they do have the correct paperwork. In the United States, the division of the government that is responsible for this is called the U.S. Immigration and Customs Enforcement, commonly known as ICE, which is one of the Department of Homeland Security sections. And it is the one that, not surprisingly, is engaged and focused on enforcement. In the fiscal year 2012, there were 520 criminal arrests. And this isn't just investigations, this is the actual arrests related to worksite enforcement. And of those arrests, 240, these are not arresting the foreign national or the undocumented immigrants. These are arresting the HR employees, the supervisors, the managers. This could be many people on the call today. So this is something you really should be concerned about. You don't want your HR manager or frontline supervisor being hauled away in handcuffs by an ICE agent. The charges are listed here: harboring or knowingly hiring illegal aliens, in the words of the ICE website, aggravated identity theft, Social Security fraud, and just on that a related note, on just this past Monday, on June 17th, ICE raided 7-Eleven. They arrested many owners of 7-Eleven franchises in New York and Virginia, and they were accused of harboring undocumented immigrants, sometimes for as long as 13 years, and they also raided 30 additional stores, 7-Eleven franchise stores across the U.S. So this is not just a theoretical issue. Into fiscal year 2012, the Immigration and Customs Enforcement issued 3,004 notices of inspection. And I'm going to talk about those in a little bit later on the slide. That is the first step in an inspection, an ICE inspection of companies. It is not necessarily a sign that there is something wrong. They sometimes do this randomly, but it issued 3,004, which was a massive increase from the, let's say, a few years earlier. In 2004, the number of notices of inspection was 4. This past year, it was 3,004. And this is 495 final orders of decisions and 12 million in fines. So that's very, very significant. And it debarred 376 businesses. And when I mention in the next slide as well, but when it says a bar, this doesn't mean that the company is simply barred from immigration filings in the future. It could be and is a bar on these very, very lucrative government contracts as well. So if your company is engaged in any business that has contracts with the government, this could be a very severe penalty. So what generally are the penalties for? Just that the previous slide gave a very overall broad view of the ICE's enforcement, but what are the actual individual penalties that are possible? For the first offense of an I-9 violation, from $375 to $3,200 for each unauthorized employee. Going up, the second offense is higher again, up to $6,500. Third offense up to $16,000. So hopefully none of you will get to even a second or a third offense, hopefully not even a first offense. There could be criminal sanctions if there is found to be a pattern of abuse that could be up to 6 months in prison. And again, like the previous slide says, this is not necessarily your CEO or the hiring manager. This could be any manager. It could be an HR professional. There's pretty broad sweep. Other possible sanctions include the ban on government contracts that I mentioned earlier, and also the negative publicity that I mentioned the 7-Eleven, that there was a lot of publicity about that earlier this week. I'll talk about an Abercrombie and Fitch violation and penalties in a few minutes. But negative publicity may not actually be as significant in the U.S. as it may be in other countries. If you are a company that is doing immigration in other countries, if you're a multinational corporation and you have branches in other countries, the effect of negative publicity in other countries can be very significant. There can be some countries, like in Asia in particular, where saving face, as they call it, is incredibly important, and being seen as an untrustworthy and publicly shamed company can really negatively impact your reputation in that country. I mentioned the Abercrombie, and the immigration doesn't release the reasons why these notices or these fines are imposed. They don't say what was the problem, but there have been apparently some reporters that have got copies of documents through Freedom of Information Act requests and have discovered that approximately half of the fines that are issued are for what I would say mere paperwork violations. That means there may have been absolutely no evidence of hiring undocumented workers or anything shady at all. It was simply that this fairly complex and confusing I-9 form was not completed correctly. And that, Abercrombie seems to court negative publicity, and that's what happened a few years ago with them. Apparently it was because the I-9 software they were using had a glitch in it. I think it didn't update the form. So it wasn't that they were hiring undocumented workers. It was that their forms were incorrect, and they were fined over $1 million. So just for technical paperwork violations. Now, as I mentioned, I-9 inspections increased dramatically between 2004 and 2012, up by 3,000. The process for an inspection starts with a notice of inspection, and this comes from the Immigration and Customs Enforcement Agency, and it gives the employer 3 business days notice that an inspection is going to take place and that the documents need to be ready, the payroll records, the I-9 forms, and other documents. Once the inspection has taken place and the inspector physically does come to your offices and look at the paperwork, the various possible results. The notice of inspection results, which basically is a compliance letter saying that they have found no errors. There is a notice of suspect documents, which means there's possibly an undocumented worker and you need to prove that this person was not undocumented. There's discrepancies where eligibility wasn't clear, and again, there's a chance for the employer to correct that. And there is nearly always some discrepancy or some uncertainty for technical failure because it's extremely difficult, especially in a very large corporation, to have all of your I-9s absolutely perfect. Sorry, this is... So how can you hopefully avoid an audit, or at least if you are audited or inspected, what can you do to minimize your chances of having any problems arising? Well, firstly, ensure that you're using that new form that Alan mentioned earlier from May the 8th. If you haven't started using it, go back and correct all the I-9s. Conduct self-audits or hire a law firm. Like Alan's mentioned that his firm does audits of I-9s. If you have a very large company, perhaps have yourselves or an outside law firm come in and audit maybe 10% of your I-9s just to make sure that things are not, that they are being done correctly and that there aren't any serious problems, that clearly there's training of your staff or your HR staff needed. This also, any of these steps are going to help explain to the ICE official, if there is something that shows up, it's going to really help explain that to the ICE official, that you really tried to do it properly, that you weren't just negligent about the forms. So creating a corporate policy, and again, this will help show the ICE official that you tried your best, and including in that the latest version of the I-9 form so that there's no doubt as to which version. And I put government-issued version there because there are some employers who will take out the form, print off the form, and maybe then put their own company logo on the top of it, because they want to brand it, understandably, but it's no longer the official I-9 form, so you can't do that. And set a date by which to complete the I-9. They should be completed within 3 business days. So make sure that there is some specific date, that you put it in the policy and it's very clear. Okay, when do you expect the form to be completed? And make sure that the HR is educated, and every new HR that comes in is educated on the most recent I-9 requirements. Include in this policy whether you're going to keep copies of the supporting documents that are used to verify employment eligibility. Alan mentioned that some lawyers recommend copying, other lawyers don't. Whether you do or you don't, if you do copy, you have to copy for everybody. If you don't, you have to not copy for everybody. So it's very important that your policy specify, are you a copying company or a not copying? And include your process for purging I-9s. There are reports of people being fined for I-9 violations, or technical paperwork violations, when the I-9s could legally have been purged. You don't purge them when you hear of an inspection. I'm not recommending shredding. But if you're legally able to purge the I-9s, we recommend purging them when you can, because you don't want to be fined for a paperwork violation on a form for somebody who left the company 10 years ago and whose I-9 didn't even need to be in that file. That's just talking about the I-9 compliance issues. As I say, there's day-long webinars or seminars I could give on the compliance minefield that surrounds immigration and international work. Some other subjects or areas in this include complying with the labor condition applications. If your company is one that files a lot of, or any H-1Bs, it is important to comply with the LCA, labor condition application requirements, including updating LCAs if the person moves from one location to another, if they change to part-time from full-time. There is an enormous amount of compliance surrounding LCAs alone that just do not have time to go into today. And that in these areas, I-9 and LCA compliance, very often it's not an inspection that draws the attention of ICE, but it's a disgruntled employee who contacts the immigration, ICE or whatever agency they contact, and makes a complaint, and that triggers an investigation. Oh, one of my favorite topics is the misuse or abuse of the business visitor category. If you're involved in immigration, if you're bringing people into the U.S. from overseas or sending them out from the U.S., it's almost certain that at some point people are using short-term assignments or business visitors or stealth expats, I've heard them called, where they are going into a different country as a business visitor and really working. That is, in very few countries in the world, including the U.S., it's not lawful to work in visitor status. And working can cover a lot of what is considered working. Really, it doesn't matter. People often think, well, he's only going to be there for 2 weeks, or she's going to stay on the payroll in India, so it's okay. None of those are relevant. It doesn't matter where they're being paid. It doesn't matter how long they're staying. It matters what they're doing. If they're providing services to a U.S. company that a U.S. employee could do, they are working. They're not appropriate business visitors. If they're coming in to attend business meetings, if they're coming in to attend an exhibition of some sort, to receive training, that's okay. But there is enormous abuse of the business visitor category that it's very important to educate the managers within your company, because these may not even ever go through an immigration department or travel department. Okay, I'll get off my soapbox on business visitors. And other areas to be aware of are Foreign Corrupt Practices Act, which affects companies, and most of the listeners on this call are going to be U.S.-based. However, it does affect companies that may seem to have a very, very tenuous connection with the U.S. When I'm dealing with immigration partners in other countries, especially in Asian or in African countries, I have to be very clear that our company will not support paying any bribe, handling charge, facilitation fee, whatever they call it, to a government official. In a lot of countries, I had a lawyer from Bangladesh on the phone the other day, and this was a lawyer, and he said to me, oh, you have to pay a handling charge, he called it. You have to. He said, you have to, or you won't get an approval. You won't get anything. And I said, we won't do that. We just won't. But it just seemed to be so normal that this lawyer was saying it quite openly. Privacy laws are important to be aware of, especially if you're dealing with European Union countries. The EU directives on privacy are very strict, much stricter than nearly any other country in the world or any other region in the world. So it's very important that if you are involved in transmitting personal data from anywhere within the EU in particular, or even regarding an EU national, that you get consent to transmit that personal data. And that could be anything as simple as a passport number, because it's impossible to provide immigration services without providing what is called this personal data, like date of birth, like passport numbers. So that's important to be aware of. And while this is not a seminar on tax issues, I just want to bring up the fact that a lot of people think that there is this 180-day bright line rule as regards when a person is subject to tax in a new country, that if they don't spend 180 days, then they're not subject to tax. But that's only certain countries. There could be some countries, like I believe Egypt, where it's just a few days. So don't rely on that 180-day rule, but do get expert tax advice depending on the country that you are in. And that is my portion of the webinar over, and I will pass it on to the next presenter. Thank you very much.
Okay, thank you, Elaine. Raul and I are going to briefly chat about preference visa categories. And so you should have on your screen what I call my visa chart, which changes each month. And it starts off with the family-sponsored categories, and then the next part of it is the employment-sponsored categories, and it tells you where these categories are up to. And basically, and those are available on my website or anybody who wants a copy, but basically, as far as the present preference visa categories, we're talking about either family-sponsored categories or employment-based categories. And so the family-sponsored categories, first of all, there's the immediate relative category, which is the husbands and wives of permanent residents, the parents, husbands, wives, American citizens, the parents of American citizens whose children are over 21, and the children under 21 of American citizens. That's the immediate relative category. That's not on this list because there are no backlogs. There's no waiting times for that except for processing times. The next category is F1, unmarried sons and daughters of U.S. citizens. Second category, F2, spouses and unmarried children of permanent residents. F2B, unmarried sons and daughters of permanent residents. These unmarried sons and daughters are over 21. F3, married sons and daughters of U.S. citizens. And F4, brothers and sisters of U.S. citizens. Now, this again is present law. I think this is going to be changing if we have a new immigration law. Now, the employment-based categories, we have E1 priority workers, and the priority workers have three subcategories: aliens of extraordinary ability who can sponsor themselves, aliens with advanced. The second is international exceptional workers and college and university professors who are exceptional, and the third part of the E1 priority workers are international business people. These were the people who could qualify for L1, but they're immigrating directly. E2 is professionals holding advanced degrees or persons of exceptional ability. Some of them can sponsor themselves with the national interest waiver. E3, skilled workers and professionals. EW is other workers, unskilled workers. Some lawyers jokingly call the EW category eternally waiting. E4 are certain special immigrants like religious workers. And then E5 is employment creation or investor visas. Now, very briefly on the employment creation, the immigration law originally said that a person who invests at least $500,000 in an area of high unemployment and a new business which would generate 10 new jobs can get an immigrant visa. If it wasn't an area of high unemployment, it would be $1 million. And they were thinking in terms of somebody would start their own business in a depressed area and work in that own business and develop a business, and 10 new jobs would come out of it. Now we have pilot projects also. It's been liberalized a little bit, so you can invest in a pilot project which you can invest in an area of high unemployment in a pilot project. You don't have to go there. You don't have to work there, but you're investing $500,000 in the pilot project, and your investment would generate 10 new jobs. There may be 100 different pilot projects, but there are only a few that really have been around long enough to get somebody the first card, which is a 2-year temporary card, and then to have the 2-year condition removed to change it into a permanent card. So that's the EB-5 investor visa category. Let me just bounce over to Raul to make some comments, and Raul and I will go back and forth on these preference visa categories. Raul?
Yeah, I was going to say that, with regards to EB-5, actually, it's become a cottage industry as of late, especially since the economic crisis in 2008. In globalization, a lot of foreign entities and governments and companies are investing much-needed capital in really, really, hurt areas of the United States, for example, in Detroit, Michigan. And this is a huge business for corporate counsel to get involved with, because it really is one of those things where much-needed capital can be available for distressed companies. And I encourage all of you to look into the EB-5 visa categories. Again, as Alan was saying earlier, it is a pilot situation. It's been that way for many, many years. For some reason, it has never been able to get off the ground completely. There's always been a couple hang-ups as to the source of the funds, and in light of the Terrorism Act and the Patriot Act, people want to know where the money's coming from overseas. But essentially, it is a $1 trillion industry, and it is $1 billion, and it's moving forward. So I would encourage all of you to look into the EB-5 categories. Also, with regards to the
and the EB-5 category role, sure. We know that in some situations it's possible for that money to be loaned to you, the $500,000, and still be able to do an EB-5 case.
Absolutely.
Right.
$500,000 for rural and $1 million for an urban area. And going up to the top of the list that Alan was talking about, the EB-1A category is like sort of the holy grail of immigration visas, in the sense that you can dispense with the necessity for doing a Department of Labor, certification under PERM, or whatever the case may be, which can also be time-consuming, can result in auditing. The EB-1A, if you can get your client, if he's truly extraordinary, if you can get him to do a self-petitioning situation without the need for a sponsor or time-consuming or audit-prone Department of Labor certification, by all means do that. And the higher you go up the totem pole, the faster it is for your client on the scale.
And just what Raul is saying, you can look at my visa chart, and under the employment-based categories, all the categories are current. That's the people who sponsor themselves, aliens of extraordinary ability, outstanding professors and researchers, and international business people. They're all current. See, that's what the C means on the visa chart. These visa chart, this comes out every month from the State Department, and these numbers change, but the first category is completely current for every place in the world.
Alan, quick question for you. I mean, so you're saying that all of them are current. In the EB-1A is extraordinary, even for India and Chinese nationals and high immigration areas?
For the whole world.
Fantastic.
And that's why clients will frequently come to the lawyer saying, I want to be an EB-1, or, please move me up, or let me see if I can file under alien extraordinary ability or outstanding professor or researcher or whatever, because they know it's current. And as you go down, you can see that some of the other categories are not current. There are backlogs in some of the other categories.
Alan, for Indian and Chinese nationals as opposed to, say, European countries, what are the differences in the wait periods of time for adjustment of status to permanent residence?
Well, the weight differences are considerable because, if you look at the chart, the first line is all chargeability areas, and then the second line is China, the third line is India, the third across is Mexico, and the fourth is the Philippines. Those are countries where there are much longer waits. So if we look at for example, the second preference category, professionals holding advanced degrees or persons of exceptional ability, for the world it's current. But for China, backlog for July 15th, 2008. For India, backlog to September 1st, 2004. The same thing going down with the E3. Again, backlogs. There are backlogs for the whole world, not just India, China, Mexico, and the Philippines. And EW, the same thing. Now, there's going to be a lot of changes in these backlogs, and when we we'll talk about it when I talk about comprehensive immigration reform. But Congress is planning a lot of changes on this stuff. Raul?
So you would say it definitely behooves you, if you have a client from those high immigration areas, to look up the higher food chain levels in the EB categories and try to get them to dispense with the labor certs and dispense with the sponsorship situation. Okay.
Yeah, see, the nice thing about the E1 category, the priority workers, none of those require labor certification, because going through the Department of Labor is usually a headache. The second category, professionals holding advanced degrees or persons of exceptional ability, sometimes requires a labor certification, sometimes not. Most of the time it does. People who file for national interest waivers where they sponsor themselves don't need a labor certification. There's also something called Schedule A Group 2, which is an automatic labor certification where you don't have to go through the Labor Department. But Schedule A Group 2 is sort of like Monopoly, go directly to immigration, pass the Labor Department. And that's for people of exceptional ability, a notch below extraordinary ability. And those people who can get a Schedule A labor certificate, there's a list for Schedule A. We can send that to you. I tried to get it into my slides. It didn't come out. But so Schedule A is an automatic labor certification. You don't have to go through the Labor Department. Normally that will come in with the EB2 category. I guess occasionally with E3 category also.
Alan, why don't you tell our audience a little bit, what are the different types of labor certifications? I mean, we've heard PERM, regular, RAR. What are the differences, different types of labor certifications, and what are the
right now there's just one kind of labor certification, which is called Schedule A is an automatic labor certification, but the general labor certification is called PERM. It's an automatic labor certification where the employer does 7 different things. The employer has to do a job order with the State Employment Service. The employer has to advertise the job in a newspaper, if it's a professional job, in a newspaper of general circulation on a Sunday twice. There are about 7 different things the employer has to do on a PERM to show the Labor Department that he or she couldn't find local people, and the employer has to show they're willing to pay prevailing wages, what an American would get for the job. So I like to tell people it's like going fishing. It's like you put a hook in the water and you show the Labor Department you couldn't find qualified fish. It's a tedious process. It all must be done within 6 months. You must file electronically with the Labor Department. So it can't go on and on. From the first recruitment thing that you do, which normally is placing the job order with the State Employment Service, till the 7th thing, which is for the professionals and less for the non-professionals, you must hit the button and file with the Labor Department. Do this automatic labor certificate, file it electronically. Now, the next step will be either you get an approval from the Labor Department. Rarely will you get a denial, but it could happen. Well, more frequently you get an audit where the Labor Department says we're going to audit you. They don't come and visit you. They send you a notice saying they want to see a certain number of paperwork things that you were supposed to have saved when you started the PERM process. So the individual labor certification is called PERM. The Schedule A labor certification is automatic, and people who don't need labor certifications would be in the E1 category.
Well, what are some of the things that trigger an automatic audit from the Department of Labor?
Okay. Well, we got about 30 seconds, so let's do it quickly. Some things that could trigger an automatic labor certification, frequently, but not all the time, if a language is required, you'll get an audit. Not all the time, but frequently. Frequently, if it's a business where you indicate on the form that you or close relatives own part or all of the company, you're going to get an audit. So the number of other things, but those things come to mind quickly about the languages and where the alien who's being filed for owns part or all of the business or his relatives do.
What about it's over 10 people in the company as well?
Over 10 might or might not. Raul, I think we're out of time.
Let's move forward, yeah.
Let's swing into comprehensive immigration reform, which is very interesting. Now, as far as comprehensive immigration reform is concerned, S-744 is the Senate bill. The Senate bill is moving forward. They hope to have it finished and voted on by the full Senate by the end of June, maybe beginning of July. One component is legalization, where people would become registered provisional immigrants. They'd be required to pay a penalty and back taxes. Individuals in this RPI status would receive work authorization, could travel abroad, and they would be eligible to apply for permanent residence status after 10 years and for naturalization 3 years after acquiring the green card. This includes also provisions for dreamers and agricultural workers who would be able to become permanent residents quicker than the 10 years. As far as family-based immigrants, it would move the 2A category for permanent husbands and wives of permanent residents, children of permanent residents, into the immediate relative category. It would allow for derivatives of immediate relatives, which is really good now because if an American citizen files for his wife, the kids are not included, he has to file a separate petition. It would eliminate the FB4 category. Brothers and sisters of American citizens would be eliminated. So if you know anybody who's an American citizen and wants to file for brothers and sisters, do it right away, because sooner rather than later, the category is going to be eliminated. It would cap the eligibility of married sons and daughters of U.S. citizens at 31. As far as employment-based immigrants, which a lot of people on this call are interested in, it would exempt the following categories from the quota. EB1 immigrants exempt from the quota. Doctoral degree holders exempt from the quota. Physicians who've completed the foreign residence requirement and derivatives exempt from the quota. And add a new, and as Raul, you mentioned this, add a new EB6 category for certain entrepreneurs. Now, as far as temporary workers are concerned, it would create a W-1 visa for lesser skilled workers, a W-2 visa for aliens coming to the U.S. to perform agricultural services or labor under a written contract, and a W-3 visa for at-will workers with an offer of full-time employment in an agricultural occupation. The W-2 and the W-3 visas would replace the current H-2A agricultural worker program. For E-Verify, it would require all employers to be on the E-Verify system after 5 years. As far as H-1Bs, it would increase the quota to a floor of 110,000 and a ceiling of 180,000, increase the U.S. advanced degree exemption, which is now 20,000 to 25,000, but limit it to STEM graduates. It would add a requirement for all H-1B ELF labor condition applications to have a detailed posting on an internet site designed by the Labor Department, and this has been hotly debated and may change. It would add a non-displacement attestation, change the prevailing wage formula, provide working permits for spouses of H-1Bs, which is really nice, and add a 60-day grace period after an H-1B has been terminated for his or her job. Now, some really new things that I just discovered, which is fascinating. Right now, there are 300,000 unused employment-based numbers that were available between 2000 and 2012, and about another 300,000 for families. The Senate bill would allow these unused numbers to be used, and it would clear the backlogs entirely, practically, for employment-based immigration and family-based immigration. Both the House and the Senate have this provision in their bills. Now, one more thing that's kind of really fascinating, they're going to create a new visa, a new non-immigrant visa called an E4. Many of you know that E3 is for Australia, and they get $10,500 per year. They don't have to file an H. If you're a professional, you go into the American consulate in Australia or somewhere else, you file for an E3 visa, and that was to reward Australia for its help in Iraq. Now, this new E4 visa, there would be 5,000 E4 visas available per country that have a trade agreement with the United States. No petition necessary. Just show up at the consulate. They have to be professional jobs. Again, these have to be specialty occupations from free trade countries. So this is really hot stuff, because almost every country, many countries, England, France, would all be eligible for 5,000 E4 visas like the Australian E3. Now, it's a very obscure provision. It's Section 4402 of the Senate bill, page 1733. And it's just fascinating that you, instead of just Australia having E3 visas, and the nice thing about this is that you wouldn't have to go through the H-1 quotas. You wouldn't have to, do all the things you have to file an H-1 petition. Now, problem with H-1s under this new legislation, the wage scale would be higher for H-1s, people starting out. So right now, an H-1, all H-1s have to get prevailing wages. Somebody just out of school and who's going to be filing for an H-1, the wage scale is going to be much higher than normal. And so that's going to be a big problem in terms of employers maybe not wanting to do H-1s for new hires, for people lower down on the prevailing wage scale. Now, this H-1 things are not in the ESA bill, which is the House bill. So what we have is now pending in the Senate. We have 744, which has already gone through the Senate Immigration Committee, the Senate Judiciary Committee, and it's pending on the floor of the Senate now. The House, we don't have much. I mean, what the House is doing is they're putting in different individual bills. And so the one bill that I listed on the slides is the ESA bill, which is called the Supplying Knowledge-Based Immigrants and Lifting Levels of STEM Visas Act. It's by Congressman Dan Issa. And the ESA bill really deals with employment-based immigration. So this is some of the changes that are going on, but at the same time, there's also an E5 visa which they're talking about, which would be just for people from Korea. And there's an interesting article from USA Today which talks about all these little things that they're trying to tuck into the Senate bill and probably into both bills, where foreign retirees could live in the United States for longer periods each year if they agree to make cash investments. Overseas snowboard instructors could enter the U.S. Under visas that are now reserved for athletes. So what's happening is that special interests are putting in all kinds of bills. There's a provision in the Senate bill which sets aside 10,500 visas each year for Irish immigrants. There's a provision granting foreign retirees age 55 and older a 3-year renewable visa if they invest $500,000 in U.S. real estate, and they have to live at least 6 months each year and have health insurance. There's a separate measure which would allow older Canadians to remain in the United States for up to 8 months each year, up from 6 months. To qualify, the Canadians must own a home here or have a long-term rental agreement. They have to have health insurance. So there are a number of these little goodies that everybody is tucking into at least the Senate bill, the House bill, and I think a lot of these, if we have a new immigration, we're going to see a lot of this. And there's a lot going on in terms of the temporary workers, and it's hard to realize that they've got a bill going for foreign ski and snowboard instructors by allowing them to work in the United States under the same program which would be used by professional athletes and entertainers. So keep your eyes on this stuff. We will. What's going to happen is a bill will probably pass the Senate. They just need 60 votes, and then focus then turns on to the House. And the question then is going to be what's going to happen in the House. Congressman Lufgren, who is the minority leader in the House, very interested in immigration. She was once an immigration lawyer. Is very interested in a lot of, and coming from the Silicon Valley, she's very interested in H visas. She's very interested in employment-based immigration. So it's a question of what's going to happen when the bill gets to the House. Will the House just accept the Senate bill and debate it? Right now they're putting in individual bills. It's a question of what's going to happen, but eventually we will have a bill that passes the House, hopefully, and then it'll probably go to conference committee, where there'll be a number of senators and congressmen on the conference committee to try to homogenize the bill. And there's an article in today's New York Times talking about Congressman Bona and what he would agree to if it ever got to conference committee or if it ever got to being voted on the floor of the House. So this is really very hot stuff in terms of what kind of new immigration law we're going to have, and are we going to have anything coming out. But I think this is on a fast track, meaning that they want to get this whole thing finished by the end of the summer. They don't want to be debating immigration, they meaning congressmen and senators, they don't want to be debating immigration next year where all congressmen are running for re-election. So we will know soon, are we going to have a new immigration law or not, and what's going to be in this new immigration law. But I'm kind of, as I said before, really interested in this little odd provision about E4 visas, 5,000 per country, like the Australian E3, and this is for countries which have a free trade agreement with the United States. And then, as I said, noticed this morning that they've even added an E5 visa just for Korea. And then I mentioned before that they've got 10,500 visas each year for Irish immigrants. Everybody's getting a little piece of this. So that's basically my take on what's going on with the new possible legislation. And I'm going to turn to Raul, who's going to talk about DACA, Deferred Action for Childhood Arrivals, DACA. Raul, what's happening? Tell us about DACA.
Well, as a follow-up to what you were talking about earlier, and this is sort of to intro the DACA stuff, I think the reason that this immigration reform is coming down the pike is because literally the immigration laws are now almost like Swiss cheese. They've been so pumped full of holes and loopholes and exceptions thanks to great immigration litigators around the country. I mean, and also not necessarily due to Obama's liberalization of the immigration situation. The recent things that he's done, for example, instructing ICE and enforcement not to go after people who don't have any violent criminal convictions, for example, leaving them be. Obviously the deferred action, which I'm going to talk about later, the DACA issues. So there's a bunch of things that have happened, and plus also the U visa, the advent of the U visa, which also you can immigration practitioners, skilled immigration practitioners, can use to target unscrupulous either immigration practitioners or district attorneys or prosecutors, even Department of Labor officials, whatever the case may be, to keep your client here. So there's so many exceptions at this point that literally there's no case that's not winnable. I was also going to ask you, Alan, before I get into DACA, you were mentioning the W-1, the W-2, W-3s, and also the EB. What about those undocumented workers that are here now, say from Latin America or wherever, who used to have to file an overstay waiver or a provisional waiver if there were removal proceedings at the consulate or here in immigration court. Oh, by the way, this is also I neglected to mention that Obama's provisional waiver. Now you can file a waiver when they're not in immigration court, correct? A hardship waiver, or when they're not at the consulate. So that's another thing that Obama did to really help immigrants move forward. So I think that's one of the reasons this comprehensive immigration reform is coming down the pike, and also not in any also due to the fact that the economy is in the toilet right now, and we need the immigration system to be fixed because immigrants definitely help the U.S. economy. Moving around of globally skilled workers to the United States of America has historically helped the United States, especially in the 90s, the H-1B boom, with the Silicon Valley situation of immigrants from India and China and Asia and that kind of thing. But Alan, regarding the W-1s, 2s, and 3s, and also with the E-5s, E-6s, is there now still a necessity to do a provisional waiver or an overstay visa waiver with this immigration reform, or can we just go right ahead and apply for these things while they're in the States?
I would say when Raul is talking about provisional waiver, what he's talking about is that some people are not eligible to get an immigrant visa in the United States because they came without a visa for other reasons. They just can't adjust here. They have to go out. And normally, if they go out, they may need a waiver to come back. A waiver could be because they're subject to the 3- and 10-year bar, meaning if they're here illegally more than a year, they're subject to a 10-year bar. If they're here illegally more than 6 months, they're subject to a 3-year bar. They need a waiver. And so President Obama's administration came up with something called a provisional waiver, where certain limited people who are married to Americans an I-130 petition has been filed and approved. There's only one issue in the case, which is subject to the 3- and 10-year bar. They can file a waiver here, wait here, and if the waiver is approved, then go home and pick up their immigrant visa without a problem. Otherwise, most people have to go home, appear at the American consul. American consul says the case is good, but you need a waiver. Wait here until the waiver is approved, and maybe they're sitting back in the home country for 6 months or 12 months while the waiver is being processed. The provisional waiver is very nice because there's a limited group of people who have only one issue, the overstay, can file the waiver here, wait here, and if and when it's approved, go home quickly and without having a problem. That's the provisional waiver. Raul, back to you.
Okay, well, I'm just looking again. We were just talking really quickly about some of the legislation that President Obama has passed, especially in the last 6 months to a year, which really has eased the lives and minds of many, many undocumented immigrants in the United States, whether they're corporate professionals or whether they're agricultural workers. Obama's legislation have really helped people to adjust. I think this has also ushered in this comprehensive immigration reform because it's just untenable not to do it. Because essentially any skilled immigration practitioner worth half his salt can literally take advantage of the multiple remedies and get your client a green card or permanent residency or keep them with their families regardless. So this is a high time coming, and it's going to come because I think there's a crying out from the district attorneys and ICE officials and everything saying, look, this is just ridiculous. They're getting what they want anyway. So I'm going to dive in really quickly and talk about one of those remedies that Obama had passed, which is the DACA, which is Deferred Action for Childhood Arrivals. And that's only, again, one of them, but we don't, the time permitting. So essentially, let's just dive into it. On June 15, 2012, the Secretary of Homeland Security announced that certain people who came to the U.S. as children and met several key guidelines may request consideration of deferred action for a period of 2 years, subject to renewal, and would then be eligible for work authorization. So this essentially is really good for a huge chunk of the population. Now, I don't know how much this will apply to corporate counsel, but, it's one of those things wherein it may or may not be useful for their children or for other people who may be involved. And also, it freezes in time the age bracket, I think 31 years old, which we'll talk about later, so they can take advantage as well. The deferred action is a discretionary determination to defer removal action of an individual as an act of prosecutorial discretion. Again, it's discretionary, meaning that it can be denied with little to no grounds or even without an appeal, which is definitely an interesting tenet. Usually you're given a 290B, you're allowed 30 days to appeal any kind of adverse decision from the USCIS, and also you're able to file a motion to reopen or a motion to reconsider. But in the DACA situation, oftentimes if you're denied, there are no grounds for appeal. And there are no 290Bs, and they'll say it's discretionary. You may try to file a reply affidavit as a litigator, but you probably won't have very much luck. Deferred action does not provide an individual with any lawful status, so be careful. You don't want to tell your client that they're going to get a green card out of this. Essentially, it's just a process for just deferring the situation and postponing the inevitable, so that they can possibly move on with their lives, maybe get gainful employment, possibly get married. Whatever in some other avenue they could sort of resolve or fix their immigration status. You may request consideration of deferred action for childhood arrivals if you were under the age of 31 as of June 15, 2012, came to the United States before reaching your 16th birthday, have continuously resided in the United States since June 15, 2007 up to the present time, and were physically present in the United States on June 15, 2012, and at the time of making your request for consideration of deferred action with the USCIS. Now, Alan, I was going to ask you this, and perhaps maybe even Elaine, I was mentioning this earlier. If you see the language here, it says you were under the age of 31 as of June 15, 2012, and taking into account the George Bush legislation of the child CSP, I believe it was, that preserved the priority dates in that law. What about this? What if you're dealing with somebody who's now like say 35 or 34. Would that be preserved for that person, or is that
no? You couldn't file for DACA unless you were under 31 as of June 15, 12. Okay. Period.
Mm-hmm. So does that preserve that indefinitely, or was it? Yeah,
preserves it indefinitely. In other words, if you file for DACA before June 15, 2012, that you're in. I mean, if you, assuming you qualify, even though now it's like a year or two goes by and while your case is pending and you're over 31, that's all right. You had to be under 31 as of June 15, 12.
Now,
and meet the other requirements.
How would you, if you were counseling one of your clients, how would you counsel them to prove that they've continuously resided in the United States since June 15, 2007 to the present?
Well, there's a list of documents.
Especially if they're undocumented.
Yeah, undocumented people still have ways of documenting. In other words, the main thing is were they in school, because that's one of the requirements, that they had to have gone to school here. And there's some very good information on the USCIS website in terms of what types of documents, and we all went through this if we were around practicing on the previous amnesties, where obviously people who are illegal here don't have a lot of documents. But there are a whole bunch of possibilities. I mean, did they work? Did they go to school? Did they go to the doctor? I mean, but you've got to document the period of time that they have to be here. As I say, there's some very good material on the USCIS website in terms of what types of documents. And you have here in your slide, they have to be currently in school or have attained the GED, and so that that's easy to show. Ended without inspection, or been lawfully, or their status expired before June 15, 12. So a lot of these DACA cases are difficult in terms because you've got to thoroughly document them.
Right. Now, the last category also is that you cannot have been convicted of a felony or significant misdemeanor 3 or more other misdemeanors and do not otherwise pose a threat to the national security or public safety of the United States. But obviously that's, for a seasoned litigator, if there's any kind of blemishes on your client's, record, you can always go back to the criminal court and try to see if you can reopen that or kind of, maybe renegotiate the plea or even argue to the USCIS that, whatever they were convicted of in the state level did not operate as a bar to adjustment. And that, again, from state to state, different things have different consequences. Different, acts have different federal consequences. So it's good to look into your state's treatment of those issues. Again, we had mentioned before certain treatises and books that actually serve to tell you about that. The Kurzban treatise is one. Alan and I have discussed the Kurzban treatise, Ira Kurzban's book, seminal book about that, which talks about the different case law. Now we go to the next slide, DACA age requirements. Anyone requesting consideration for deferred action must have been under 31 as of June 15, 2012, as we discussed. You must also be at least 15 years or older to request deferred action unless you are currently in removal proceedings or have a final removal or voluntary departure order, as summarized in the table below. Now, Alan, quick question for you. Yep. Do you have to be in removal proceedings to file for DACA?
No. Not everybody's in removal proceedings, but basically if you're in removal proceedings, you can talk to the trial attorney and try to get the case either administratively closed or terminated. But basically, you can still be in removal proceedings, and you can file for DACA.
So you don't necessarily have to be in deportation proceedings.
No, you don't have to. Not at all.
Okay. Let's move on to a different slide here because we're talking about the same thing over and over again here. Okay. So as we see here, we're talking about the different types of schooling process. Now, look, if you meet the guidelines for deferred action under this process, you will need to complete the following steps to make your request to the USCIS. You need to obviously collect the documents as evidence you meet under the guidelines. You have to complete forms, USCIS forms I-821D, which is the deferred action form, I-765, which is the employment authorization document, and the I-765WS, which is the worksheet, which talks about, how much money you make, and it's a pretty comprehensive form. And the reason that they do this, they make WS perfunctory, is because they really want to make sure that people aren't applying for deferred action and getting work authorization, right away without really being qualified for it. Alan, what do you think about that, the WS? What is that? What is the purpose of the WS?
Well, I mean, basically, the worksheet asks people about their assets, and basically it says, why do you want to work? And most of my clients will say, well, I want to work because my parents are supporting me and I'd like to support myself. So it doesn't really matter much what you say on the worksheet. I mean, most people will get this I-765 even if they have a steady job. I mean, they're just going to get the work permit. So a worksheet isn't such a big deal. You have to instruct people about what to say. And usually I say, just put down why you want to work and just show it to me. And then if we like, then we'll clean it up and put it into the WS form.
Why does the 765 WS? Why does the USCIS want that to be filled in while you're?
Well, because they want people to have work permits, and that's one of the benefits of filing under DACA, is that if you file under DACA and you qualify, you'll get a work permit. There's some issue about whether people could get travel permits, and some of my clients are asking about that already, but I don't think anybody has it already. Roel, I think we're just about out of time, and maybe we should leave a little bit of time left for questions.
Very good.
So let's see if we have any questions that we can answer. And what we'll do is, if we have the questions, we'll read the questions. Elaine and I and you will read the questions. And okay, let's see. So let's see. What is your experience on whether or not employers keep the supporting documentation to the I-9s? I would say, and I want to see if Elaine agrees, I would say that most employers do keep the supporting documentation, even though some lawyers who are more conservative tell people not to because you could have a problem with it. So that, Elaine, what do you say about that? Yes,
I think that employers do keep it. I think it's, as said in my part, it is just important for the employers to remember that if they keep it for some people, they have to keep it for everybody, not just for the people who look foreign.
Okay, now there's another question which we both can take together. And to be entirely clear, I-9s from before May 8, 2013 are no longer valid, and all I-9s should be updated at an employer's location. Basically, if you filled out an I-9 for a previous employer, it's still good. We're talking about new hires and verification, re-verify. Those people need the new form. But
yeah, it's just that the form from before May 8 is invalid, but that you cannot use the pre-May 8 form for post-May 8 hires, but it's fine for the pre-May 8 hires.
Another question, are independent contractors subject to the I-9 requirement? Yes. The employers of the independent contractors have to have their employees I-9'd before they go out and work for other people. So, but if it's an individual who is an independent contractor and truly qualifies as an independent contractor, may not need an I-9. There's a question that's dealt with extensively in the handbook. And Elaine, what do you say about about independent contractors and I-9s?
Well, unless
do you have a comment?
I think you pretty much covered it, that the employers are not responsible unless they know of something.
Yeah, in other words, like I run a company and I send people out to work in somebody's garden. I have to I-9 those people that I send to work out in somebody's garden, but the person who owns the garden doesn't have to have an I-9 from those people. But the employer of the independent contractor who sends the gardeners out has to have them I-9'd. Let's see if we have any other questions.
One for you, Alan.
Oh, yeah, okay. Question me. Please repeat the name of my friend Ann. Okay. Her name is Ann Allott, Allott. Her book, she has a book out now, but it's being updated to take into account the new I-9s. And you can Google her. She's from Colorado. And I think that the book is being published by LexisNexis. So her present book is very good, but I think she sent me an email saying wait a few weeks and the new book will be out. Okay, now we have a question. Are J-1 trainee visa holders required?
Wait, Mark. I'm sorry, Alan.
Go ahead, Ralph.
Go ahead and answer the Mark Berkowitz question first. It's a very good question, Alan.
Okay. We use a paper-based I-9 system and have photocopies of some completed I-9 forms, but the original forms are no longer available. What, if anything, would you recommend we do in this situation? I would recommend filling out new, and I want to see if Elaine agrees with me, I would recommend filling out new original I-9 forms and attach the copies, photocopies of you that you have to the new original. Would you agree, Elaine?
Yes, I would.
Okay, another question. Are J-1 trainee visa holders required to complete I-9s? And if they're getting paid, I think they are required to complete I-9s.
Absolutely.
Every worker is required.
Yep. Okay.
It's also a good way to protect yourself. So that's why you want to filter out, because you're also doing due diligence. So in case they are, God forbid, using, fictitious documentation, which could happen, you're actually doing what you have to do, correct, Elaine?
Yes.
You're basically using it as a sword and shield.
You just have to show that you're treating every single employee the same.
Absolutely. We have another question. Do all individual household employers of domestic services, such as caregivers, housekeepers, etc., have to complete and hold on to copies of I-9s, and if so, for how long? It would seem to me that these are regular employees, not intermittent employees, and so they're working on, even though they're working 1 day a week, 2 days a week, but they work on a long-term basis, you have to do I-9s for them. Elaine, would you agree with that?
Yes, I would think if you've got a full-time live-in nanny, say, but if you've got a housekeeper who comes 2 hours every 2 weeks, I hope you don't have to do an I-9.
Well, Elaine, that's the question I was going to ask you about. Like, what if it's just a friend or the family kind of helping you out of here and there? Do you need to do an I-9 for that?
I would say if they're just coming occasionally, sporadically, maybe not. But if it's on a regular basis, once a week, once a month, probably yes. And there is a definite specific answer on that. I just didn't want to fumble with papers while we were talking. But
what about is there any dollar requirement, Alan or Elaine, in terms of how much they're being remunerated before you have to do an I-9?
No. If they're working and the I-9 doesn't relate to how much they're getting paid.
Elaine, what would you think about that?
Yeah, the I-9 relates to. Sorry.
It doesn't relate to what they're getting paid. It
right.
relates to whether they're being employed.
Very good.
Okay, let's see if we have any other questions. Nothing. Okay, I think we are out of questions. Yeah, we are. So I will turn. Thank you all for listening in.
I think we just need to continue it a little bit longer. So
yeah, okay,
until
okay.
3:35.
We've got a few more. Elaine, this is for you. Isn't there an $800 minimum on taxability?
$600 minimum. I don't really understand the question. So if
it's a taxation question, but maybe
I don't know. Perhaps if it is a tax question, then I'm not the person to answer it because that's not my area of expertise. So.
Unless they're asking
for the necessity of I-9s, I think.
Yeah. Unless they're asking for, I would say no. I would say that I-9 don't matter whether you're 800 minimum on taxability or not. If this is the thrust of this is an I-9 question, I'd say no. If it's a taxation question, now somebody asked what happened to the CLE code, and the CLE code will either be announced shortly when we're finished. We're almost finished, and it will also, I think, maybe given on the screen. So you'll have the CLE code. Okay. Now let's see if we have some new questions. Oh, okay. Can you talk about the new worker rights protections in the Senate Immigration Reform Bill? Now, basically, the worker rights protections, I think, are mainly, or maybe not entirely, with relation to the temporary workers like the V visas and the W visas. People have known for a long time that people on H-2 visas have been subject to abuses. And so there are worker rights protections that are involved in the W visas, these new temporary working visas for unskilled workers. So as far as details about them, I don't have that right at hand, but there are considerable worker rights protections. Now, we have another question. 800 minimum question might be about having to send 1099s to non-corporate workers if you paid them over $800 in tax year. And the person says, I'm not giving tax advice. Well,
I think that person is trying to help answer the previous question that wasn't very clear, or not, I shouldn't say it wasn't very clear, that I didn't completely understand.
Okay, let us see if we have some more questions. And again, on the worker rights protection, they are in the Senate immigration bill. It's just that I don't want to go through 800 pages while you people hold on. But if someone wants to send me an email, I'll get you the information about the new worker rights protections. And I would say also that if any of you have further questions, feel free to send me or Raul or Elaine an email, and we'll try to answer further questions.
Alan, we have about 10 more minutes here, I think, and one of the things that was listed on the webinar invitation and didn't really get discussed was the effect of mergers and acquisitions.
Okay, well, go for it.
Compliance. So, if you want, there is a question, but just talking about, actually there are a couple of questions, so maybe we should answer those before we go off on a different topic.
Okay, well, we have one here on the, do you want to do the merger and acquisitions before we do another one? Was there a merger and acquisition question, Elaine?
No, there wasn't a question. I was just going to, since we had...
Okay, all right, so we have some questions. On the pilot programs for E-5 visas, is there a limit on number of visa holders or on countries of origin? How long are the visas good for? Will this change with reform? Now, presently, there are 10,000 visas available for the EB-5 investors, and they're not all filled up. Will this change? I mean, they're going to have different kind of investors under the new law. You'll have the EB-5 investors, and you'll have people investing less money. The changes for Canadians. But right now it's 10,000, which is never filled up, and that's for the whole world.
Alan, also, you were mentioning earlier about the E6 and E5 categories, like you said, the Australian nationals and the Korean.
The E6 would be a temporary visa for Koreans, like the E5 for the rest of the world. And that's like the model is the E3 for Australians. So these are not green card, because EB-5, employment-based 5, is the investor green card. We're talking about E4, a non-immigrant visa, $5,000 for each country which has a free trade agreement with the United States, who would get these temporary visas like the Australians, good for several years at a time. Let's see, we have some more questions. Okay, there was a mention of certain new provisions related to Canadian citizens in the new immigration bills. Does this have any effect on current TN visas? I would say no, it doesn't have any effect on current TN visas. Has either House bill confirmed a new H-1B fee yet? I don't really think so, but I think there will be higher fees on H-1Bs, assuming that it passes the Senate and the House. I think there will be. So I'm not really sure whether it's confirmed or not. Our requirements applied to employers with 4 or more employees. Are I-9s required when there are less than 4 employees? Yes. Do you reconcile, let's see, okay, Elaine, they want you to elaborate on the business visitor rule.
Well, the business visitor rule is, it usually states that, I've heard it described as some people say they like to use something called a hands-in-pocket rule, that if the business visitor is keeping their hands in their pockets, they're not programming machine, they're not repairing machinery, they're not conducting any training, then they're eligible as business visitors. In general, if you're coming over to attend a business meeting, if your company is, if you work for Ericsson in Sweden and you're coming over to a business meeting with colleagues in Ericsson in the U.S., if you're coming over to attend a conference, to receive training, if you're doing, there's another one that violates the hands-in-pockets rule, but still okay, is that if you are coming in to perform services and installation of equipment or machinery that was bought from outside the U.S. and the contract for the purchase requires this after-sales service or installation, then you can come in and get your hands dirty in doing that work and be complying with the B1 or visa waiver business visitor requirements. That's about the only instance where you can provide productive services to a U.S. company and be in B1 status.
We have a question, a DACA question, which is for all children who qualify to request consideration of deferred action for a period of 2 years subject to renewal and would then be eligible for work authorization. Does that mean they will be eligible for work authorization only after the renewal?
No, they're eligible for it right away when you file for the DACA.
Right. I mean, that's correct. And then the CIS was saying that after the 2 years you have to file for an extension of the status, and they thought they would be optimistic that people would get the extension of the status. We may have a new law which that won't be necessary. Now,
yeah, I think the law was really just to buy time and to grant immediate relief. I think that Obama was using his veto power in a sense to override Congress, and he just felt they were taking too long, so I think he just passed this because he was trying to safeguard the rights of the young people that were in school and things of that nature. So I think he just kind of rammed that through, and he was hoping for a 2-year stretch, and that by the 2 years, then we would have this comprehensive immigration reform that you're talking about.
We have another question. How do you reconcile an I-9 where the first name is spelled one way on the I-9 form, a different way on the driver's license, and a different way on the Social Security card, and you discover after the fact in a self-audit?
Oh, well, we got it.
So, Elaine, what do you think about that?
That's going to be a very common problem where you have people who are translating their names from a totally different language that doesn't use Roman characters, say, and you're just trying to have the English version of Guangzhou, and it's like Saddam Hussein. There was no particular correct English spelling of that name.
I would also be very careful with something like that. That sounds like borderline fraud. And the FBI is always, they have they're always making mistakes anyway. I mean, people are coming in the border. Sometimes they'll even hold certain reliefs, and they'll stall the case approvals. So it's very important to get your name correct. Because at the very minimum, it will result in delays on your case. At the maximum, you could be charged with criminal moral turpitude or kind of immigration fraud.
But it is common to have a different spelling. If the name Hussein could be the same name, could be HUSS,
True.
HOSS.
Absolutely. But there have been cases where, and Alan, can I tell you, so we've had to file mandamus cases in federal court, federal lawsuits to actually just move it through because they've just been sitting in these cases for sometimes 10, 15 years. And people can't leave the United States, and then they can get detained. It's really kind of a messy situation. It's very, very important to pick a spelling of your name and go with it consistently, and not have any different kind of spelling mistakes on your thing. Alan, would you agree with that?
Yep. Now, somebody just said that we're almost out of time, and can they get the CLE code? And my understanding is you'll have the CLE code in a few minutes when we get a little closer to 3:35. Next question: if a new hire is located in a different city from the hiring manager filling out an I-9 using the company's software, is it acceptable for a legal analyst located in another city who can verify the H-1 receipt notice to let hiring manager know of the work eligibility? Well, somebody has to fill out the form, and somebody could be an agent of the employer, and that somebody has to inspect the documents that are shown to qualify as a List A or List B or a List C, and that somebody has to sign it. Now, the company will be responsible for that, but it could be somebody working for the company in the city where that person is applying for the job.
I also think that it should be done ad hoc in person with the employee and then where they're working, the premises of where they're starting the job. I don't think it's a good idea to have different agents in different cities process paperwork for people in different locations. I think that part of the process for the I-9, and Elaine could disagree or agree with me, I think that it's also the smell test when you see the documentation that the employee is providing you, whether they're originals, you're supposed to make copies of their driver licenses, their group passports and whatnot. I think part of it is also has to do with the face-to-face relationship. But I just don't think it's a good idea to do it in different cities because that creates too much exposure for employers. I think I don't know.
Yeah, it's difficult. It is.
There's some human elements, that you really can't dispense with, and I think with multinational and multi-city corporations, it's critical to have somebody in-house to handle them ad hoc in front of you, rather than having to do it from city to city.
But it can't always be done that way. That's the problem. Another question: following on the misspelled name issue, should we ask the employee to fix? And I would say yes, and I'll turn to Elaine that the employee should, on the misspelled name, bring in proof of the correct name, and then the I-9 can be amended or do a new I-9. Elaine?
Yeah, well, I think it's again, we're back to, though, if it is a name that isn't in English. I mean, if it's an English name to begin with, if it's a case of my name, Martin, and it's spelled M-O-R-T-I-N by mistake because the driver's license office made a mistake, then I can get it corrected. However, if it's because there is no correct English spelling of my name because my name is Hussein, then it's somewhat more difficult. But I would suggest getting the supporting documents if there is, say, it is a driver's license, and I can't remember what the other one was. If the person can get them all in the same name, that's definitely going to be much easier. Apart from just I-9 requirements, it's going to be a lot easier. For example, traveling, going through airports, it's just much easier to have all the documents with the exact same name.
I think another thing, it might be just easier to just get a court order. It's pretty easy to go to your local courthouse, get a judicial order about the correct spelling of the name. Because that way you can just present that simple judicial order, that document, to all agencies or entities involved, and it'll be an immediate change. Once a judge orders it after looking at all the evidence, it's very, very easy to just mail that into the USCIS, the passport office, or DMV, whatever the case may be, and just say, look, this is the spelling of my name. Please issue me a new ID, and have the correct correct spelling. I think that this affidavit stuff could be self-serving affidavits could be dangerous.
I didn't know you could get that judicial order.
Absolutely.
Okay, we have 1 minute to go, and we see if we can do one question, and maybe we'll get the CLE code. People currently in a preference category waiting for the visa to become current and not eligible for an EAD. However, a person granted RPI will be eligible for an EAD. Can someone in a preference category apply for RPI? And the answer is if you qualify for RPI, it doesn't matter whether in a preference category or not, but you have to meet the requirements for RPI, and that's still being sorted out, what things you have to show to be able to get that and get the working permit. We're out of time, and if I'm just seeing if somebody can send us the CLE code so we can give it to the audience, and I don't see it on the screen. but we will get the CLE code for you and get it to you.
Alan, this is Kathleen Regan. I have the CLE code to announce.
Oh, great. Terrific. Terrific.
If our speakers are done with the presentation and the questions, I'm happy to give the code and conclude today's webinar.
Okay. So do you want to give the CLE code? Or do you want me to give it?
No, I'm going to take care of it. I just wanted to be sure that you and Elaine and Roland were
we're finished.
Don't seem to be any more questions.
Wonderful. Thank you all very much. Attendees, today's second CLE code is 4519. I apologize. That is the first CLE code. Today's second CLE code is 1271. Again, the second CLE code is 1271.
Okay, thank
Again,
you.
1271. And I'd like to, on behalf of LexisNexis, thank today's faculty for an outstanding program. To our audience, thank you for attending today's complimentary CLE webinar. We ask that you please follow the link to our survey. Your feedback on products and services is an excellent resource for us. Thank you and have a great day.
Thank you.
Thank you.